Assalamu alaikum wa rahmatullah. Dear viewers, welcome back to this episode of the Evolution of Fiqh. As we did before, every time we start an episode, we summarize the previous ones. And in the previous episodes, we talked about the meaning of fiqh, linguistic meaning, and the terminological meaning of the word fiqh, or understanding, which is the linguistic meaning. And we said that the terminological meaning is to understand the legal rulings from the scriptural evidence. And we also talked about the scope of fiqh, and we said that fiqh, or the knowledge of the legal rulings, covers our relationship with Allah, the rulings of our relationship with Allah. This is called the acts of worship, and our relationship with ourselves and others, the Creator and the creation. Relationship with Allah is called worship. That is fasting, praying, zakah, charity, hajj, pilgrimage. And our relationship with ourselves and others is under the title of transactions, customs, etiquettes, etc. We talked about the importance of learning fiqh, and we said parts of fiqh are mandatory to learn and parts of fiqh are preferable to learn. The parts of fiqh that are mandatory to learn are the ones without which we cannot practice our religion. We cannot stay away from the prohibitions, and we cannot perform the duties and obligations. So it is mandatory upon us to learn to fast and to learn to pray. It is mandatory upon us to learn that ghiba or backbiting is haram, gossiping is haram, hatred and rancor, envy, all of these things are haram, injustice is haram. You cannot say that I didn't know, because you had to know. You had to learn and you had to seek that knowledge. As we indicated before, the Prophet ﷺ is the one who made this mandatory upon us. He said, طَلَبُ الْعِلْمِ فَرِيضَةٌ عَلَى كُلِّ مُسْلِمٍ وَمُسْلِمَةٍ. Seeking knowledge is mandatory upon each and every male and female Muslim. And certainly Allah is the one who is legislating, and Allah is the one who is making it mandatory. And the Prophet ﷺ conveyed this meaning to us. Then we talked about the source of fiqh, and we said that the source is the revelation, and the revelation is the Quran and the Sunnah of the Prophet, peace be upon him. And we did address the issue of the madhahib. Since we were talking about the source, we addressed the issue of the madhahib, and we talked about their evolution. We talked about the different scholars, their students and teachers, and we talked about the position that we should have from the different madhahib without overlooking that great heritage and without causing our following of the madhahib to be a divisive force in the ummah, breaking the ummah down into smaller pieces or parts. We then started to talk about an important concept, which is the concept of moderation versus excessiveness, because that's a very important concept. And we said that excessiveness is not the only problem. There is laxity on the other end of the spectrum. Moderation is the center, and there are two sides, far right and far left. And if excessiveness is harmful, laxity is harmful as well. Both are harmful, and we should seek moderation, which is the path of Allah. We did also say that moderation is not to moderate the religion ourselves, but to hold firmly to the moderate religion of Islam that was revealed by Allah unto Prophet Muhammad ﷺ through Jibreel. Then we talked about excessiveness, and we mentioned what excessiveness is and what excessiveness is not. We started last episode to talk about some of the concepts that are important for us to understand and digest, to be able to have a better understanding of the topic of fiqh. And these concepts are from two sciences which are very essential in the understanding of fiqh. They are considered specialized sciences. They are not usually taught to the public, but parts of these sciences are very important for us to understand in order for us to have a better grasp on fiqh. These sciences are the science of the fundamentals of jurisprudence, usul al-fiqh, and the legal principles, al-qawa'id al-fiqhiyya. We started with the legal principles, even though the legal principles are a product of fiqh, are a fruit of fiqh, not the basis or the foundation of fiqh. Usul al-fiqh, the fundamentals of jurisprudence, are the basis upon which fiqh is built. So, usul al-fiqh is the recipe by which you make fiqh. You need the recipe, and then when you make fiqh, then by the inductive method, you go through the fiqh, the different chapters, different topics, and then you make associations. You deduce general rulings from the different topics of fiqh. You find certain patterns that are consistent throughout the Islamic jurisprudence. And those rulings that you deduce from the fiqh that are like general patterns consistent throughout the fiqh are called comprehensive major legal principles. We have six of them, and we mentioned last time 3 of them, and today inshallah we'll start with number 4. The 3 that we mentioned last time were إنما الأعمال بالنيات, deeds are but by their intentions. اليقين لا يزول بالشك, which means certainty is not negated by doubt. The third one is المشقة تجلب التيسير, hardship brings about ease. The fourth one, which we will be talking about now, is لا ضرر ولا ضرار, no harm and no reciprocating of harm. No harm and no reciprocating of harm. Let's understand this one. Now, this one is one of the beauties of the legal principles. And honestly speaking, there has not been any legal system in the whole world that knew the science of usul al-fiqh, the fundamentals of jurisprudence, like Islam. Even the fundamentals of the current secular laws are not as extensive and comprehensive as the fundamentals of the jurisprudence. We know that in Great Britain, for instance, people used to go by the previous rulings in the court system, the previous edicts in the court system, and go by them. And if there is a precedent in a certain case, they follow that precedent, and so on and so forth. In Islam, it is not like this. It is a system that has a basis, that has foundations, that has general rules that should be applicable in all of the branches of fiqh or the legal system. لا ضرر ولا ضرار. What does this principle do for us? Or how do the scholars use that principle? No harm and no reciprocating of harm. Let's say, I'll give you this example. This will make it clear for us. Now, we all know that the Prophet ﷺ told us that a person and what he owns belong to his father. أنت ومالك لأبيك. You and what you own belong to your father. This is true. This is an authentic hadith, and it certainly should be applied. But let us say the father is being irrational, or the father is being unfair, and the father is overburdening his son. He's taking from his son more than he needs, or he does not need anything and he just wants to take from his son, or he takes from his son to give other siblings. Then what should we do? We have this hadith, and this hadith is specific about this particular condition. Yet, we do not only have this hadith. We have this hadith within the whole entire context of the legal system of Islam. We cannot understand this hadith in isolation from the entire legal system of Islam. So now we have this hadith and we have the ruling of la darara wa la dirar, no harm and no reciprocating of harm. So then the judge comes and says, well, you as a father are entitled to the money of your son. But this has to be within reason. If you need money, then you take from his money. But if you don't need money, then you do not harm him. Or you cannot overburden him. You cannot cause harm to him. Let's say the son has a car, just one car, and the father said, well, give me your car. According to the hadith, the father is entitled to his son's car. But now the son will not be able to go to work. And significant harm will be inflicted upon him by this. So now this is the time for this legal principle to be used. La darar, no harm. Therefore, the father will not be entitled to taking his son's car. No reciprocating of harm. This is also very important. No reciprocating of harm. It means that you do not fix something by breaking other. Let's say someone ruined your crops. Your neighbor ruined your crops or ruined part of your house. The right course of action for you is to seek justice, is to go to the court, to go to the judge, and seek justice from your neighbor. It does not allow you are not entitled to ruining his crops or demolishing his home. Your neighbor hurt your son. You don't go and hurt his son. No reciprocation of harm. It should stop at one point, and you should seek justice. And within the court system, the legal Islamic court system, you will be able to get your due rights. This principle, just like many other principles, shows us the flexibility of the religion of Islam. Certain things were not existent during the time of the Prophet ﷺ. Smoking, for instance, was not existent during his time. So can someone now say that tobacco is okay, it is halal? No, you should not be saying tobacco is halal, because tobacco is harmful. And according to this ruling, and certainly there are many other pieces of evidence on the prohibition of tobacco smoking, but this is one of them. No harm and no reciprocating of harm. Had we had no other indication that tobacco is haram from the Sunnah, the Quran, the consensus, all the other tools that are used in the making of fiqh, we would have used this one legal principle, no harm and no reciprocating of harm, and there should be an agreement between us that tobacco smoking, which results in many types of cancer, many types of diseases, and eventually results in death, must be prohibited, because there should be no harm and no reciprocating of harm. When we come back after the break, inshallah, we will talk about other concepts or other legal principles that are of great benefit for us. Assalamu alaikum wa rahmatullah.
Would like to talk about some of the things that remind us of what Ramadan's really all about. To learn some of the lessons that Ramadan teaches us, how to put that in effect in our lives, and even how to carry it forward after the month of Ramadan. So before I even pray, I need to purify my body. But before I do that, I need to purify the heart. And this is key to all of us. One of the things about Ramadan, is that nobody can actually see you fasting. The real value of the Quran is to know and understand the meaning behind it, and then to put that into our lives, put it into practice, so that the Quran becomes living inside of me, and I begin to respond to the things around me in my life according to the way Allah wants me to. This is the month of inspiration. This is the month for the revelation, and this is the month for me to have a chance to really think about my Lord. Think about what it is that He's given me and how I should be so appreciative of that. Oh Allah, You are the creator and sustainer of the whole in the universe, and we ask from You this, accept from us.
The entire staff at Huda would like to wish you a wonderful and blessed Ramadan.
Assalamu alaikum wa rahmatullah. Before the break, we were talking about some of the legal principles, and the last one that we were talking about is la darar wa la dirar, no harm and no reciprocating of harm. Now we will talk about another one of the major and comprehensive legal principles, al-qawa'id al-fiqhiyya al-kulliyya al-kubra. This one is about customs, traditions, habits of not individuals but of entire nations or the different peoples. Different peoples have different habits, and Islam is for all people. Allah subhanahu wa ta'ala said to the Prophet sallallahu alayhi wasallam, وَمَا أَرْسَلْنَاكَ إِلَّا رَحْمَةً لِلْعَالَمِينَ. We have not sent you but as a mercy for all mankind. So Islam was meant to be the religion of the Africans, the Europeans, the Asians, the white, the black, the rich, the poor, for everyone. And Islam very early on in the history of Islam mixed with different cultures and integrated those cultures in the religion without changing anything in the religion and without overlooking or ignoring the different cultures of the people. There is certainly room for people to be different. That's the diversity of mankind that is one of the beauties of Allah's creation and one of the signs of Allah's greatness, the diversity of mankind. And Islam did accept this fact and did deal with it very beautifully. Customs are to be given consideration. Now, if we make a contract, if I take like a piece of fabric for you to tailor it for me, and we make a contract, whether it's written contract or a verbal contract or lease my apartment out to you or my taxi or whatever, and then we disagree over some of the clauses, the meanings of some of the clauses, or some of the things that we have omitted from the contract or neglected to mention in the contract, the verbal or the written contract. Some of these things result in some dispute between us. How do we solve such disputes? We solve such disputes in the context of Islam, in the context of the scriptural evidence. If there are certain things that are the duty of the person who leases the property or the owner of the property in Islam, then these will be used. But in many cases, there are certain clauses that cannot be understood except in the context of the customs of the people. The customs of the people. How do they run this business in that city? How do they run this business in that part of the world? Driving a taxi in Cairo is different from driving a taxi in New York. The contracts are different in Cairo and in New York or other parts of the world. Therefore, we will use the customs, we will use the traditions of the people to understand the meanings of these clauses or of these conditions in the contract. You will also find that sometimes things are considered disliked, or not necessarily disliked, but things are considered to be not preferable, or preferable to stay away from them in certain parts of the world and not in other parts of the world, in certain times and not in other times. And Imam al-Shatibi talks about this issue, and he mentions the fact that in the Western Muslim lands, Libya, Tunisia, Algeria, West Africa, in the Western Andalusia, in the Western Muslim lands, walking out in the street without your head covered is not considered a problem. It is not considered a violation of manlyhood. Whereas in the Eastern Muslim lands, usually they refer to the East Muslim lands or the Eastern Muslim lands when they talked about Egypt and anything east from Egypt. So in the Eastern Muslim lands, walking out in the street with your head uncovered was a violation of manlyhood. It was not the right etiquette. It was not the right manner. Now, the religion does not say that you have to cover or uncover your head. The Prophet ﷺ used to cover his head. The Prophet used to wear imamah. He used to wear a turban. But the Prophet ﷺ did not tell us that wearing a turban, wearing an imamah, or covering the head is mandatory or preferable in the religion. He wore an imamah because most of the people in his time, or the people of his time in his place or city, used to wear imamahs or used to wear turbans or used to walk out of their homes with their head covered. So the customs here do have a bearing. They do have an effect on our perception of the act or the action of the person, the practitioner of the religion. But before I move on to the other legal principle, it's just very important here to make sure that customs do not change the religion. The religion does not yield to the customs. The religion does acknowledge the customs of people. It does consider them in the understanding of certain clauses. In some areas, people use the word lahm for meat for samak, fish. So if in the contract you indicated that you will sell him lahm, and you meant fish, and in this particular part of the world they use that word lahm for fish or meat for fish, then that's okay. Then that's what you meant, and that's in agreement with the customs, so we will use it. But the customs will never change the religion, will never make permissible impermissible and impermissible permissible. And this is very important to know. Many people use the fact that Imam Shafi'i changed some of his fiqh when he moved from Egypt, when he moved from Iraq to Egypt, because of the different customs of the Egyptians. The different customs of the Egyptians may have had some bearing on some issues, but Imam Shafi'i revised his fiqh like any other scholar. A scholar does not stop at one point and freeze there. Imam Ahmad ibn Hanbal changed his opinions sometimes regarding one matter 8 times. 8 times he would change his opinion regarding one matter, because the scholars do not freeze at one particular point. They are knowledgeable and impartial. They follow the truth. They have this keenness, eagerness to follow the truth. Whenever they come across a new piece of evidence, whenever they come across a new piece of information, they use it, they integrate it, they incorporate it in their fiqh, and they revise their fiqh, and they may change their fiqh based on that. Imam Shafi'i, when he went to Egypt, he revised his fiqh. Certain things changed when he took another look at his fiqh and his opinions. But it was not the customs who made him change his opinions. The use of all pieces of evidence is our next legal principle, which is called al-i'malu awla min al-ihmal. Using all pieces of evidence is given precedence over neglecting some. And that does not only apply to the religion, but it applies even to the speech of the people. To use all of the statements when we make a contract, for instance, and a verbal contract, and then go to the judge regarding some dispute between us, the judge should ask us about all of the contract, all of the clauses, everything we mentioned, and should take all of this in consideration to make a better judgment. The same applies also to the understanding of Islam, the understanding of the different scriptural evidence. We cannot say we will use this hadith and overlook the other one. If both are authentic, both must be used. If both ahadith are authentic, both must be used. There is no way that the two authentic ahadith will contradict each other. There must be a way to reconcile between them. This way to reconcile between them could be by like a formula, a conciliatory formula. It could be by abrogating one of the two ahadith by another one. You know, if we have the dates of the ahadith confirmed, one can abrogate the other one. But there must be a way to reconcile between the hadith. But you cannot simply say, well, I'll just go by this one and overlook or omit this one. Because al-i'mal awla min al-ihmal. Using all pieces of evidence takes precedence over using some only. So now, when we use this in our life in general and our interactions with others, it will add to our impartiality. We can even use this to be more moderate in our assessment of things, in our impartiality. It's a concept, and the concept is not necessarily only used in fiqh, but it could be also used in life in general. And sometimes when we like someone, we only remember the good things that he says or does and forget the bad things. And when we dislike someone, we only remember the bad things that he says or does or she says or does and forget the other ones, which is wrong. In our assessment of people, we should take all of their statements, all of their sayings, all of their actions, all of their behavior, and make an impartial assessment of the entire person. And that's what impartiality is about. So the legal principles do not only teach us how to understand our deen and how to understand the fiqh, they are concepts. They are great concepts that we can even use in our life in general. After the legal principles, we will have some talk, inshallah, about the fundamentals of jurisprudence. The fundamentals of jurisprudence. And like the legal principles, the fundamentals of jurisprudence is another topic that is considered very specialized. Only the scholars or the students of knowledge are the ones who study this particular topic. But I think that it would be a great idea to get some of the benefits or some of the points that will be beneficial for the common Muslims, for the public, out of these two sciences, and put them in a book that will encompass these points and make it available or accessible for the public, because these are great concepts that are very beneficial, as we said, in our general understanding of the deen and our life in general as well. The first part of the legal principle, the fundamentals of jurisprudence that we will be talking about, is the part about the different categories of rulings, the different grades or different categories of rulings. Everything in this life has a ruling in Islam. Has a ruling in Islam. Is this statement right? No, it is not. Every action in this life has a ruling in Islam, because things do not have rulings. You know, the monitor does not have a ruling. The keyboard does not have a ruling. The desk does not have a ruling. The TV does not have a ruling. Watching TV may have a ruling. You know, pigs do not have a ruling. Eating pork may have a ruling. So every action in this life does have a ruling in Islam. These rulings are divided into 5 categories: mandatory, preferable, permissible, disliked, and prohibited. When we come back in the next episode, inshallah, we will go over them and we will have a discussion about the different types of rulings. Assalamu alaikum wa rahmatullah.